It gives me great pleasure to welcome you to today's roundtable entitled Understanding Leave Options in the Federal Workplace and Misconduct Implications. Today's presentation will provide expert knowledge on the topic of federal leave systems and how to address conduct issues that can arise with respect to time and attendance issues and leave abuse. We encourage everyone to make the most of the roundtable, including asking questions of our presenters. You may do so by sending an email to employeeaccountability@opm.gov. We will do our best to field as many questions as possible. Brenda will take her questions at the end of her remarks, and Melanie will take questions throughout her remarks. Please note that shortly following the presentation, everyone who registered will receive a hyperlink to an online evaluation form courtesy of SurveyMonkey.com. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. Your feedback is important to us and helps us plan future roundtables. For this significant topic of understanding leave options in the federal workplace and misconduct implications, we are delighted to have as our presenters today Brenda Roberts and Melanie Jones. Brenda Roberts is the Deputy Associate Director for Pay and Leave Employee Services. She was appointed to the Senior Executive Service in October 2014. Brenda has more than 30 years of federal human resources experience in compensation-related areas. She is responsible for the overall administration of laws, regulations, and policies related to pay, leave, premium pay, and hours of work for approximately 2.1 million federal civilian employees worldwide. Melanie Jones is a senior attorney with the U.S. Department of Justice, Justice Management Division, Office of Labor and Employment Law. Melanie's office is responsible for providing guidance to department components on labor and employee relations and overseeing the department's Labor and Employee Relations program. Melanie joined the Department of Justice after serving as a staff attorney in the U.S. Office of General Counsel, Employment and Labor Law Division at the U.S. Department of Commerce for 10 years. We are delighted to have Brenda and Melanie as our presenters today to share their expertise in this vital area. Please join me in welcoming Brenda Roberts and Melanie Jones.
Thank you, Cynthia. As Cynthia said, my name is Brenda Roberts. I'm the Deputy Associate Director for Pay and Leave. My office is responsible for pay, leave, work schedules, and we do the government-wide policy. The leave objectives that we have today, or my part of the presentation, will be covering an overview of the federal leave system with a focus on leave for medical purposes. We're going to cover the roles and responsibilities of Congress, President, OPM, and the agencies, managers and employees' rights and responsibilities, knowledge of differences between entitlements versus flexibilities, specific medical documentation, and we also have a variety of resources that are available for you. I have a lot of slides that are in this slide deck, and I apologize in advance because I'm going to be moving very quickly through them. But I wanted you to have them as a resource that you would be able to use in the future. So the next slide, I wanted to talk to you a little bit about the positive impacts of the leave program. You can read here the agencies and the employees' positive impacts. Basically for agencies, it's a wonderful recruitment and retention tool. We have a very good leave system. It's very generous. For employees, it's a wonderful work-life balance issue. In the EVS scores, Employee Viewpoint Survey, it's always ranged in the 80s as far as employee satisfaction. In fact, it was so successful that they took it out of the actual EVS statistics. Next, I'd like to cover the roles and responsibilities. Congress, of course, enacts the laws on leave, and they're codified in Title V of U.S. Code. The President will occasionally issue executive orders or presidential memoranda on discretionary leave programs. A lot of these are leave without pay or excused absence. OPM will take these laws where we're given the authority and regulate. There are actual leave laws that did not provide OPM with regulatory authority. Some of them would be like military leave and excused absence. Typically, we issue guidance on any executive order that the President would issue or a memoranda, and then we delegate it down to the agencies. Agencies are responsible for the administration of leave, always have been. They must be consistent with law regulation. They must consider collective bargaining agreements as they go through. And as far as entitlement versus discretionary programs, it probably seems obvious, but when you have a law and they're referring to will and shall, that usually indicates an entitlement. Basically, entitlements would be examples of FMLA or sick leave. Annual leave is an entitlement, but it has a discretionary component to it. As far as discretionary, a lot of the laws will have a may in the actual law. That's usually how you can indicate that there's some flexibility surrounding the leave. Many of the discretionary programs are advanced annual leave, sick leave, creditable service for when you have a new hire. As mentioned before, with the discretionary entitlements, the annual leave is an entitlement, but the scheduling of annual leave, that's where you have some discretion. It's always the right of the employee to request the annual leave, subject to the right of the supervisor to actually approve the leave. And as far as FMLA, annual leave can be denied if it's outside of FMLA. You put it into the Family Medical Leave Act, which is the FMLA, and then it becomes an entitlement, and the agency would have to grant it. I would like to show you a little of the federal leave system programs and policies. I do not plan on covering all of these leave entitlements, leave flexibilities today. I just wanted to provide you a little bit of the history behind it. Leave is as old as, I believe the first law was enacted in 1893. It was an annual leave law. It wasn't until the 1980s, though, that they took it outside of the annual leave and sick leave and decided to provide additional flexibilities to employees. In 1987, they introduced the Federal Leave Sharing Program, which was a pilot program at that time. In 1993, they took this program and made it a permanent program. FMLA was enacted in 1993, which provided job protection. You also have executive orders such as the executive order provided by President Bush that provided 5 days of excused absence to returning reservists. Also, the NDAA for 2008 and 2010 provided FMLA entitlements to covered service members. So that just provides you a brief history. Today, what we'd like to focus on is leave used for medical purposes. It's basically annual leave, sick leave, FMLA, leave transfer, leave bank programs. We're all familiar with annual leave. You use this for vacation, you use it for emergencies that may happen if your car breaks down, or for personal business. The annual leave accrual is 13 days for someone with 0 to 3 years of service, 20 days for someone with 3 to 15 years of service, and 26 days for 15 or more years service. SES, senior leaders, scientific technical positions, they start out at 8 hours of annual leave, which was something that wasn't, that was passed not too long ago. The approval of annual leave, I think we discussed this a little bit already. It's the right to request leave. The employee has the entitlement to request leave, subject to the right of the supervisor to approve leave. Advanced leave. Advanced leave is always discretionary. However, President Obama issued a memoranda on January 15th, 2015 on modernizing federal leave policies for childbirth, adoption, foster care to recruit and retain talent and improve productivity. In this memoranda, President Obama provided, he wanted to ensure that employees were provided some type of paid leave. So he was strongly encouraging agencies to provide advanced annual leave and advanced sick leave for this purpose, including the use of intermittent FMLA. So they basically wanted to ensure that everybody had a form of paid leave for childbirth, adoption, foster care. Now, it's not always in the employee's favor to have this leave advanced to them because they have to pay it back. So basically, the employees should be counseled to let them know that if they are advancing the leave, and for advancement of annual leave purposes, it would be the amount of annual leave they have in the remainder of the leave year, to let them know that they have to pay this leave back. So they would have to refund it, or if they separate, they would have to pay it out of, say, a lump sum payment for annual leave at the end, if they had it, or pay that was actually due to them. The only exception would be if the employee dies, retires on disability, or separates as a result of that disability. Next, I'd like to cover sick leave. Sick leave, you accrue it. It's 4 hours biweekly pay period. For a part-time employee, it's 1 hour for every 20 hours that they work on common tours of duty. It's prorated. Sick leave doesn't have a maximum carryover, so you could keep accruing and accumulating your sick leave, no limitation. Types of sick leave that we have that I would like to talk about is for personal needs, for family care and bereavement, care of a family member with a serious health condition, and adoption-related purposes. To cover the first, it's for your personal needs. I think everybody's familiar with the sick leave for that purpose. It's you don't feel good, you have to call in sick that day, you have a routine doctor's appointment. It's for items such as that. Now, when we get into the family member, this is the definition that's used for sick leave purposes and for voluntary leave transfer purposes. It's a very, very broad definition that covers your spouses, the parents thereof, son and daughter's parents, brothers, sisters, grandparents. This definition was just changed actually in 2010 to clarify that domestic partners were included, and also grandparents and grandchildren. Prior to that time, there is a clause that is the last bullet in the slide that says any individual related by blood or affinity whose close association with the employee is equivalent to a family relationship. This is basically how our domestic partners were covered before, and our grandparents and grandchildren. But President Obama wanted to make clear that these people were covered under the definition of family member, so we changed the regulations to include this. Still, the last bullet, agencies are, they use that last bullet to cover, say, aunts that raise you or cousins or anyone that is not specifically referenced in that definition, but whose close association with the employee is equivalent to that of a family relationship. 13 days of sick leave. This is for routine care of your family member. This was something that was actually introduced in 1994. Prior to 1994, you were only able to use actually sick leave for your own purposes. We didn't have family members included in. So in 1994, they provided this 13 days. This is also used for bereavement purposes. So for funerals, this is the type of leave that you would be using. For funeral leave, this would basically cover making arrangements for the funeral, attending the funeral, necessary travel for the funeral, any gatherings that you would have, the reading of the will. However, any estate sales or cleaning of the house, anything of that sort would be more appropriate to use annual leave or leave without pay. Sick leave to care for a family member with a serious health condition. That was also changed in 1994. You're allowed to use 12 administrative work weeks of your own accumulated sick leave for a serious health condition. Serious health condition is defined. You do have to read the definition of serious health condition very closely, though. It's not necessarily always what you think. So it not only covers an employee who has a medical condition, a serious medical condition like cancer or something of that sort, but it also includes incapacity due to pregnancy and childbirth or for prenatal care. One of the questions that we get is, can you use sick leave for morning sickness? That is something that an employee can use for a serious health condition. Sick leave for adoption. Adoption, this was put in 1996, and the goal of this was to put them on equal footing, basically with biological parents. There's no limitation to the amount of sick leave that you can use, but it has to be for purposes necessary for the adoption to proceed. So this would include appointments with adoption agencies, court proceedings, required travel. In some instances, it may also be for the bonding period after, but only if the courts say that this must take place for the adoption to proceed. We've been told that in China, they typically require the parents to spend a full month bonding with the parents in order to prevent something called attachment disorder. So that month would be covered under the sick leave for adoptions. Advanced sick leave, the next two slides will be dealing with advancement of sick leave, whether you can use 240 hours, which would be more for your serious health conditions. That's the maximum that can be advanced. Or the next slide would be dealing with 104 hours, and that would be for your more routine appointments and medical care. And again, under President Obama's memorandum, he strongly encourages agencies to advance the sick leave for pregnancy, childbirth, and adoption. Again, employees should be counseled before they use the advanced sick leave because they do need to pay the leave back. The only exceptions, similar to the advanced annual leave, is if the employee dies, retires on disability, or separates as a result of that disability. This is a summary, basically, of the sick leave limitations for the different purposes. It's unlimited for your personal use and for adoption. Adoption has to be related for the adoption to be processed. General family care, 104 hours. Care for a family member with a serious health condition, 12 weeks or 480 hours. And then the advancement could be 13 days or 240 hours based upon what it's being used for. Okay, requesting sick leave. Requesting sick leave can be done in different ways. We used to require what they called a standard Form 71. That's no longer required. OPM switched it years ago to make it an optional form. So agencies have different ways of actually having their employees request leave. Could be an email, could be placing it on a calendar that they have developed, could be for a number of things. Administratively acceptable evidence. This is determined by an agency. May require 3 days, in anything in excess of 3 days. However, they could actually do this for shorter periods of time. Medical deadlines. An employee must provide administratively acceptable evidence for medical certification within 15 days. However, if the above is not practical, despite the employee's diligent, good faith efforts, is what we always refer to, they must be provided with time, but no later than 30 days. Okay, the next type of leave I'd like to cover very quickly is the Family and Medical Leave Act. Department of Labor and OPM are given the authority to regulate FMLA. Department of Labor, they cover the private sector, state and local governments, and some small federal agencies. OPM, we administer Title II of the FMLA, and it covers the majority of the federal employees. FMLA is basically 12 weeks of unpaid leave during a 12-month period, and it's being used for the following categories. Basically birth, placement of son or daughter for adoption, care of a spouse, son, daughter, serious health condition of the employee, or qualifying exigency. If you will notice, family and medical leave is used for family and medical purposes. So what staff always states is it's not only for medical reason, it's also for the birth or adoption of a child and for qualifying exigencies related to the military. FMLA definitions, you'll notice that under FMLA, the definition of family member is much narrower than the definition that we talked about for sick leave and for voluntary leave transfer. It's basically the spouse, which can be opposite or same sex, son or daughter, or parent. Actually, in April 8th, 2015, we changed our regulations for based on Defense of Marriage Act to basically clarify that spouse can be used for same-sex domestic partners when they are married, but you have to be married in order to be able to use it for your spouse. The next definitions are basically covering what the definition of a son or daughter. If you look in the previous slide, son or a daughter is anyone under the age of 18 or 18 years or older and incapable of self-care because of a mental or physical disability. The following two slides will provide you additional information on what that encompasses. And I'm just going to flip through very briefly. Now, this is what a serious health condition does not include. So it's your physical eye exams, conditions requiring over-the-counter medicines, cosmetic surgery, employee's absence because of illegal substance, but that doesn't cover somebody who has to be in rehabilitation. That, of course, would be covered. Common cold, flu. Requesting leave under FMLA, it's very important because this is different than Department of Labor, but employee must invoke FMLA to use FMLA. You cannot invoke FMLA for the employee. And generally, FMLA may not be invoked retroactively. Notice of foreseeable need. You would, in the best of all circumstances, want the employee to provide 30 days calendar notice of the need to take leave, say if it was for childbirth or adoption even. Sometimes that's not always practicable, and in those cases, it will most likely be less than 30 days. Can't control some things. When it is unforeseeable, basically you provide it as soon as you can. Under no conditions, though, should you be denying the employees leave if they need to go. For example, we have received complaints where, say, your father has a terminal illness and you need to go to your father, but you're waiting for medical documentation or something of that sort. That shouldn't be. You should be letting the employee go on provisional leave. You can worry about the medical certification and sorting all that out afterwards. FMLA is an entitlement, and the employee should be able to take care of their own. Intermittent or reduced schedule. Basically, intermittent is used a lot with a serious health condition. Basically, you need to go to the doctor's appointments when you need to go to the doctor's appointments. Where it came into question is when you're dealing with the intermittent or reduced schedules because of the birth or adoption of a child. That was discretionary for a long time. However, again, with the January 15th memo that President Obama put out, he is strongly encouraging the use of FMLA on an intermittent basis for that purpose. The next slide gets into the protection of employment. Upon completion of the FMLA, the employee must be restored to the same position or equivalent position with equivalent benefits. Employees may file a grievance if the agency does not comply with the FMLA rights. An employee's request for FMLA leave does not prevent an agency from taking the appropriate adverse actions or performance-based actions. Melanie may be talking about that a little bit later. An employee on FMLA is not immune from the impact of a RIF situation during or after the FMLA leave. So those are important points to make. With FMLA grievances, it is important to know that Congress did not provide OPM with an oversight authority on this. This is all done through agency internal procedures, either through collective bargaining or your agency policies. Department of Labor was given the authority, OPM was not given the authority under a law. Next, I would like to go through medical certification process. For a lot of this is basically talking about what you need for medical certification. The first slide is for basically the employee. Second slide is for care of the family member and what is needed for medical certification, and what is needed on an intermittent basis. I'm not going to read through these slides for you, but if you have questions, you can ask later. Then I'd like to go to the medical restrictions. One thing that's important on that is if the form is incomplete, the manager or the employee can go back and ask the employee to have the healthcare provider complete it. If anything is unclear and they need clarification, you have to get the healthcare provider that's employed by your agency a under an administrative oversight to actually contact the health provider. But under no circumstances should a manager or your HR representative actually contact the health provider. It has to be done through that medical person. If you have questionable medical certification, if you're questioning the original certification, the agency can always request a second opinion. It's paid out at the agency's expense. If the original and the second opinion vary drastically, then you can ask for a third opinion. It, again, is at the agency's expense, and the third provider is picked by someone who's mutually acceptable to both parties. If the medical treatment must begin immediately and the agency is still questioning the validity, the FMLA is given on a provisional basis. Okay, recertifications. Recertifications may be done, but no more than every 30 days, except for the following conditions. If the employee requests an extended period of time. Secondly, if the circumstances described in the original medical certification is changed. For example, if you have someone who has migraines and they've applied for FMLA under that, and they end up with a brain tumor, then that would be a reason for a recertification. Or the third one, the agency receives information which casts doubt on the continuing validity of the medical certification. This would be someone who, say, has a very bad back condition, but someone sees him outside and he's building a deck. That would be something that you could go for recertification. Medical deadlines and certification, it's the same as the sick leave. It's 15 calendar days and 30 days if, despite the employee's diligent and good faith efforts, they're not able to do it within 15 days. Okay, leave sharing is the last program that I would like to cover. I'm going to flip through here very quickly because I'm running out of time. Your voluntary leave transfer program and your voluntary leave banks are basically your donated leave programs. Your voluntary leave transfer program is required for an agency to have, but not every agency has a leave bank program because it's discretionary. For available paid leave, an employee has to exhaust his or her own available paid leave in order to qualify for a voluntary leave transfer program. They have to be in a leave without pay status or assumed to have been in or going to be in a leave without pay status for 24 hours in order to qualify for the voluntary leave transfer program. So basically they have to have a medical emergency, which is defined here. They have to have a threshold for a substantial loss of income, which is 24 hours, and they have to meet the definition of family member, which is the same definition that's used in the sick leave program. So they have to exhaust their available paid leave. This doesn't count if you have advanced leave or other forms of paid time off, such as credit hours, comp time off, religious comp time. Donated leave may be used for the same reasons as annual leave, and it's approved for the same purposes. Termination of the medical emergency, which qualifies you for the donated leave. This is basically that the agency needs to be monitoring the employee throughout the process to make sure that they still qualify for the medical emergency. And the termination of a medical emergency. This is always a hard one. You may have some people that qualify for a voluntary leave transfer program that will get into the program, but really they will never be back to work because of their medical condition or basically because of their medical condition. Basically, this is not a substitution for leaving them on leave for long, long periods of time. So usually in those cases, what ends up happening is the employee will end up going out on disability retirement. And sometimes agencies will need to counsel the employee's family members on this issue. So that's going through very quickly. Interaction of annual leave and FMLA. Basically, this is what we talked about before. Annual leave can always be turned down unless it's under FMLA. If an employee invokes FMLA, they can substitute annual or sick leave. If they substitute annual leave in the FMLA period, the agency has to grant it. Interaction of sick leave with FMLA. Sick leave and FMLA, they are very distinct entitlements. You can use sick leave without invoking FMLA. So usually if you're wanting to help an employee with a serious health condition, what you would advise them to do is let them use their sick leave because they have an entitlement on their own, and then let them invoke FMLA. That provides them with job protection for a longer period of time. The next slides are giving a comparison of the sick leave program with the FMLA program. It's there for your use. This one is talking about the definition of family member. And then the second slide is talking about the similarities between the sick leave, voluntary leave transfer, and the FMLA system. The last thing I'd like to cover is leave without pay, which is basically a discretionary authority. It's granted at the supervisor's discretion, except in the following instances where it is an entitlement. That's under FMLA. Once the employee invokes FMLA, that becomes an entitlement for a 12-week period. Under the uniform services, there is a provision under USERRA for leave without pay. There's also a provision, this one is an executive order for disabled veterans who need necessary medical treatment for a service-connected disability, which they are allowed to have leave without pay for that purpose. And the last is for workers' compensation under Department of Labor, that they're granted leave without pay. So that covers my portion. And I'd like to turn it over to Melanie.
Brenda, would you entertain a couple of questions?
Oh, I'm sorry. Yes.
The first
Sure.
question, are there any exceptions to the rule that FMLA may not be invoked retroactively?
Yes, there are exceptions to that rule, and I'm going to have to get back to you on what they are. That would be something that I assume that we could send out to
Absolutely.
everyone
We will
after the
definitely
fact.
send that out.
I am actually filling in for my main staff member who is actually on sick leave today. She just had surgery, and she knows more of the specifics on that. So we will be happy to get back with you. Is that any other questions? Okay.
All right. So let's talk. Brenda has given us a lot to think about with regard to leave flexibilities and leave rules and leave regulations. So I'd like to spend a few minutes talking about what happens in the real world when things don't go exactly as planned, and managers and supervisors have to manage these flexibilities with regard to their employees. So just a brief overview of the module objectives. We're going to talk about methods by which to establish expectations regarding leave. We're going to talk about methods by which to identify leave-related misconduct, and we're going to identify and explain tools with which to correct leave-related misconduct. All right. So just in general, and I'll go through each of these in a little bit more detail. So if you're a supervisor, what are you going to do? What are the first few things that you think about when managing in the leave context? The first thing is going to be make expectations clear to your employees. We're going to discuss how to be consistent in your application of rules and regulations. We're going to talk a little bit about documentation, and we're going to discuss identifying potential concerns promptly and taking corrective action promptly. So let's talk about establishing expectations, which is another way of saying giving notice or telling your employees what to expect. And what I like to tell my managers and tell my supervisors is every good outcome really begins with you telling your employees what's expected. We want to start at least in any relationship, which is the same with the employment relationship, with the expectation and the hope that employees want to do what's expected. They want to do what we want them to do. And in order for them to accomplish that, we have to tell them what our expectations are. And that is the same with regard to leave as it is with regard to other types of conduct. So how do you tell your employees what you expect? There are a number of different ways. You can post and or announce regulations and procedures. And how do you post? Well, one way, if you're in a unionized environment, is in the collective bargaining agreement. And I would strongly recommend, if you're a new supervisor or a new manager, or even one who's been there for a while, that if you're thinking about leave and how to address leave, you refer first to your CBA. That will have very detailed explanations of how employees are to request leave, when it can be denied, separate and apart or in addition to some of the regulations that Brenda has already discussed. If you're not in a unionized environment or if you're in a mixed environment, the website is an excellent way to put general expectations. Frequently, agencies will put their leave orders on the website so employees can avail themselves of the rules, they can inform themselves, managers can touch base with the website and see what's expected. Staff meetings are another great way to publish your expectations, and sure, they may be in the order, they may be in the CFR, but how do you tell your staff what you want with regard to how they should request leave, what you need in advance, what you don't need in advance? A staff meeting is a great way to publish that widely so that your employees know what you need and what you expect. Same thing with staff newsletters or emails. Now, the last bullet really we'll discuss a little bit more later, but that's sort of when you may have had an issue or a specific question. You don't have to tell the whole staff a rule that you really are applying or an expectation that you only have to one employee. You can send a specific email to an individual employee that either clarifies your expectations or answers a question that they've asked or addresses a thing that is specific to them. Consistent application of rules. The first rule is if you have a rule or a policy or a procedure, use it. I can't tell you how many times I've had managers, say, well, this employee isn't doing this and I don't know what the answer is to this question and I don't know what to do. And I'll say, well, what's the rule and did you use it? Well, I'm not sure if there's a rule and no, I didn't use it. So if there's a rule in place, use it with regard to all of your employees, or at least refer to that rule as the starting point with regard to a leave issue. Now, consistent application does not mean identical application. So you don't have to treat every single person in exactly the same way because circumstances dictate outcome and circumstances dictate how you might respond to a particular leave question, particularly with regard to reasonable accommodation responsibilities. So you may have to, or you may choose to, or you may need to give leave to an employee in a different way or in a different time or have a different requesting policy or a practice with regard to a reasonable accommodation case. Circumstances happen, life happens, and so you have the discretion as a supervisor to be flexible in your application of the rules. And the way that looks in real life is you may have someone who's got an accommodation that relates to leave. Other employees think that that employee is being treated differently and they want to confront you and say, well, why do I have to do X when he has to do Y? And the answer is, I'm enforcing federal regulations. I'm not going to give you any details, but please be assured that I'm following the rules appropriately. If there's something that you personally need me to look at or address, I would be happy to do that. So don't get caught in the trap of thinking this is the rule and I don't have any flexibility. Rules do have flexibilities, and as long as you can explain why you've exercised the flexibility, you should be in good shape. Documentation. keep accurate records. And my inclination would be that you should always keep accurate records before you have a problem or an issue or a conflict. Be in the habit of keeping track of who's on leave, whether they've properly requested it, which leave you've approved. In instances, if you've had to deny leave, jot down why you denied it, what circumstances led to your denial. If you've exercised one of your flexibilities and varied from what you normally do for good reason, then document that good reason. If there's a dispute, document how you resolve that dispute. If an employee said, hey, I don't really think you should have denied my leave, do a quick note to the file that indicates what you said, what happened, and how you resolved the dispute in question. Similarly, if corrections are required, document the nature of the error and document the nature of the correction. Everybody makes mistakes, so there's really nothing that can't be corrected, and don't get caught up in, oh, well, the record says this, and we coded him as AWOL, so we can't change it, or I approved the leave, but I shouldn't have, I can't change it. Of course you can change it. You just have to explain why you're making the change and document that clearly, so that going forward, if you need to look back and explain why you did something, you're in the position to do that both from your own recollection, but more importantly from the documented record. So how do you identify potential leave concerns? And again, we start with the expectation that employees want to do what you've asked them to do, and that they're going to behave consistently with the rules that you set out. And sometimes that doesn't happen. And sometimes you kind of are thinking, is this a problem? Is it not a problem? I don't know. I'm feeling some kind of feeling in the pit of my stomach. I don't know if there's an issue. So how do you figure out whether there is a leave concern? And I would refer you back where we started, to the first rule, to your regulations, to the procedures. What, in the general sense, should employees be doing? And you look at that. And if you're feeling or noting or seeing that an employee is deviating from that, then there's some steps to take. And the first thing you're going to do is sort of look at your most recent history. Have they been absent for the last 2 or 3 pay periods? And during those pay periods, is there a pattern that they're absent on Mondays, that they're coming late, that they're calling at the last minute, or they're not calling at all? What actually is happening with that individual employee? Once you've identified that, you're going to just make a note. And how you document it is really purely up to your personal preference, what works for you, what is consistent with your style as a manager. Some people use charts. Some people keep all of their leave information on that giant desk calendar that is too giant, and then once you put your books on it, you can't see it. But some people use that. Some people just have a separate leave calendar, and they put everything, all things related to leave, on that calendar. Now, what I will say is stick to the facts. Employee was here or wasn't here. Employee called or didn't call. This is not the place for your editorial comments, thoughts, or subjective beliefs about why they weren't here. Anything you write, and pretty much anything you say, ultimately could be discoverable either through the Freedom of Information Act, or if we're in litigation, is discoverable in the litigation process. So make your recordations factual. These are to jog your memory. These are not to write your subjective beliefs about, gosh, I bet he was out playing Pokemon Go, what a jerk. This is the time to write down whether they were there or not, so that you can decide whether there's a problem that needs to have the next step taken. And further to that, I would say if you don't want to talk about it, don't write it. If it's something that's inappropriate for discussion with the employee, you shouldn't write it. And if you're writing something about an employee, it should be something suitable for them to see, read, and discuss. That goes to all types of anything that you're writing. Employees have the right to know what you've written, so assume that they're going to see it and be pleased for them to see it, because it should be an accurate reflection of what happened. So moving on. So what if we've done our chart, we're looking, we see, oh, there is a problem. This employee is not conducting themselves consistently with our leave rules and procedures. What's the next step? Well, as I said at the beginning, every good outcome really starts with a conversation. And I like to think of counseling as a conversation where you start out and say, hey, I've noticed a pattern. I'm not sure what's happening, but I've noticed on Mondays you're not here, or I've noticed on Tuesday you get here 30 minutes late. And I just want to show you my notes and see, is that consistent with your recollection? And then you move forward from there. They may say, yes, that's true, and I've been having this issue. Or they may say, yeah, no, I don't think that's right. But whatever it is, everything has to start with a conversation and a question. They may well have an issue that every Tuesday the bus is late, and so they haven't been able to get their kids to school on time. They may say, Monday nights I watch football until 11 and I'm really tired, and it'll be better in the spring. Whatever they say, and you decide how you're going to respond to it. But the counseling is not punitive. The counseling is to open communications so that you can see if there's a problem. If there is a problem, and that's your chance to say, I don't like it when you're late on Tuesdays, would you please come on time? Or if you are going to be late on Tuesdays, maybe we need to look at changing your tour, because if 9 o'clock doesn't work for you, maybe 9:30 will work, but I need you to be reliable and predictable in your attendance. So can we talk about how we can both be happy and have a place of yes? That's what a counseling discussion is meant to do. And so that is what I mean when I say outline expectations. You're going to talk about your rules, you're going to talk about your procedures, and you're going to say what you want. And give the employee a chance to say, yes, I can do that, no, I can't do that, I can do that, but I can't do this. Whatever the interchange is, that's what's appropriate at the outset of a I'm putting problem in quotes, at the outset of a situation. And then you're also, and this is the part that managers sometimes don't do, but you must do because it's uncomfortable, convey the consequences if there's not a change. I need you to do X, Y, and Z. If you do not, then these are the things that will happen as a result of your failure to do what I've asked. That's a little uncomfortable, but again, in order for us to move forward, we have to have that step happen. And so what are possible consequences? You can do a leave restriction. Ultimately, if the leave restriction doesn't work, we'll talk about what disciplinary actions will happen. But everything has to start with a conversation of expectations and consequences. So let's talk a little bit about leave restriction. A leave restriction is a non-disciplinary letter to the employee that conveys essentially what we just talked about in the counseling. Your policy expectations regarding leave usage, specific information like you have, negative 2 hours of leave, the last time you worked a full pay period was X, whatever you want to put in the leave restriction that summarizes how we got to this point. Why am I putting you on a leave restriction? And a leave restriction is just the imposing of more specific, more stringent rules that are really part and parcel of the larger set of rules that you already have in place. So these are, you, Mr. Employee, have to follow these call-in procedures. This is what I need to see by way of documentation. It's very specific. You should set out the time period for the restriction, and again, the consequences of not following the parameters set out in the letter. Now, I will say I have seen people use leave restrictions, and by the time I get it, someone's been on leave restriction for a year and a half. That's too long. You use the wrong tool. Leave restriction is meant to help a person get back on track for a finite period of time. It's not a forever home for the employee to live in, because if they're on leave restriction for a year and a half, I would suggest that we haven't been doing things or monitoring closely enough, and another discipline needed to happen somewhere in that period of time. So leave restriction is a tool, not a permanent solution. All right, so let's assume the leave restriction doesn't work and you're continuing to have issues with an employee with regard to attendance. What are the types of charges that we would bring based on leave or attendance issues? And we'll talk about each of these. We've got absence without leave, which is AWOL, failure to follow leave requesting procedures or instructions, and excessive absence. So AWOL. AWOL is, and you see the elements here, and I won't read them, but AWOL is you were supposed to be at a particular duty station at a particular time, and you were absent without being on approved leave. That's what AWOL is. It's exactly what it sounds like. So let's briefly talk about the difference between leave without pay and AWOL. Leave without pay is an approved leave category by definition. It's absence that is granted by the agency at the employee's request. Two things about leave without pay. One, you can't make an employee take leave without pay. So you can't say you weren't here, I'll just put you on LWOP. And two, you don't have to grant it, except for, as Brenda discussed, in the FMLA context where they're under an approved FMLA certification, in which case LWOP is not discretionary. AWOL is entirely different. It is by definition a leave status that reflects that you were not on approved leave. It is a leave designation. It is not punitive. So some people will say, well, I already punished them. I made them AWOL. Well, AWOL is just what appears on their time card. That means that they weren't at work that day and they're not going to get paid. That is not punitive. It is a status designation. We'll talk later, and I'll explain that you can use AWOL as the basis for discipline, but AWOL by itself is not discipline, nor is it punitive, unless you think not getting paid is punitive, but that's different. All right, so let's talk about failure to follow leave procedures. And as a general rule, if someone is AWOL, it sometimes also means that they fail to follow your leave requesting procedures. So what are the components of this charge? It's the agency has a procedure for requesting leave, and that's important because if you're going to charge someone with failing to follow a procedure, by definition, you must have a procedure. And this is where we go back to where we started our conversation. You have to have set an expectation. And with regard to a leave requesting procedure, it's nice if you actually have it and it's written and you've published it to your employees so that you can say, I had a procedure, they knew about it, and they failed to follow it. You must have those things in place in order for this charge to work. And then you've got the failure of the employee following the procedures, but those are the components. So let's say you've got a person who was AWOL because they didn't call in, you haven't heard from them in 4 days. You would charge them with both AWOL, which is the absence without leave, and with failure to follow your requesting procedures, assuming that calling in when you aren't coming is one of those procedures. Even if they bring in medical documentation that indicates they in fact were not AWOL because they were sick and incapacitated for duty, you could still sustain the failure to follow charge, assuming they weren't incapacitated and completely unable to call. So as a general rule, I would say these charges are go hand in hand, and I generally, if I have an AWOL charge, I also have a failure to follow charge. And we're going to talk a little bit about excessive absence. This is the one category of leave that, or of discipline that can be charged even in the face of leave that has been approved. And I'm just going to read to you the components of this because all the words in this particular charge actually are important. All of these criteria, which are referred to as the Cook criteria, are vital in sustaining this charge. So you've got an employee that was absent for a compelling reason beyond his or her control, so that approval or disapproval was immaterial because they could not be on the job. The absences continued beyond a reasonable time, and the employee was warned that adverse action might be initiated unless the employee became available for duty on a regular, full, or part-time basis. Now, that second one is important. It's not just that you warn them, if you don't come, you will be AWOL. You must warn them that if you don't come, you may be subject to adverse action. That's key. You have to warn them that their continued absence and unavailability could result in adverse action. And the third, you have to have informed the employee that their position is needed and it has to be filled by an employee available for duty on a full or part-time basis. If these elements are all in place, even if an employee has been on leave without pay or approved sick leave or approved annual leave, in the period leading up to this charge, you can still charge for excessive absence. Now, one caveat, you cannot include your FMLA period of absence in your total count. So if you say you've been out for 6 months, that 6 months has to exclude the FMLA period of time, and that should be made clear in the notice to the employee as well. Yes, Do I see a
Melanie, we
question?
have a question with respect to the Cook criteria and how it is applied. The agency wants to know, under what circumstances would the employee's response be acceptable in that the agency would not need to take action?
Their response to the I know you don't know because you're reading me that question, so you can't clarify.
In response to sending a letter along the lines of the Cook criteria, when should the agency expect that the employee's response does not require disciplinary action?
I would say I would need to look at it, and one thing that is not one of the Cook criteria, but certainly I would think relevant in deciding how you're going to move forward, is the employee says, yes, I've been a wreck for these many months, but I will be there on Monday and I am fine. I would consider it. Now, it doesn't necessarily mitigate the previous absences, but that might be something you would consider and look into the circumstances surrounding that particular response or that particular claim. Similarly, if the employee says, no, actually, your count is wrong and I haven't been out for the amount of time that you've said, or there have been other circumstances that weren't accurately recounted in any of your notices, that's clearly something you would consider because you want to be factually accurate and react to what's actually happened if you've had a misunderstanding with regard to the length of absence.
And under what circumstances would you say that an agency should propose removal instead of suspension?
With regard to what particular
This same
violation?
scenario with respect to the Cook.
Excessive absence is generally a charge that is the basis for removal, because really what you're saying is you've been absent for such an extended period of time, we need someone to fill this position. So it doesn't make logical sense to suspend you for another 30 days because that flies in the face of our need to have someone doing the job. And what I would say with regard to all of these charges, let's remember why we're all here. The job of a manager or supervisor, and then in greater degree of the agency, is to accomplish the mission. So your discipline related to leave should always be with an eye towards how is this behavior that just happens to be leave related impacting the mission of the agency. So I'm not going to suspend you for 30 days because you haven't been coming to work and I need you here. If you haven't been coming to work because you can't, then what I need is someone to unencumber the position so the position can be filled. Likewise, if you're always AWOL, I'm not removing you because I'm shaking my finger at you. It's because you're AWOL. It's that you're not helping me accomplish my mission, and so I need to make it possible for the mission to be accomplished. And so everything is informed by our need to accomplish the mission. Every single discipline, every single action that we're looking at with regard to leave is how to allow the employees to have their entitlements and still accomplish the mission. It's never, an us versus them. It's a we. All of this is about how do we get to the end, which is our mission, and how do we do that with compassion and with allowing our employees to take advantage of their entitlements, but at the same time do the job for which they were hired. So if you take yourself back to that and inform your decisions based on that principle, it's sort of easier to figure out how to navigate some of these and what to charge and when and how strict you want to be with some of these flexibilities.
We have another question with respect to FMLA. When an employee has submitted medical documentation that supports intermittent FMLA, however, subsequent to that, the employee is saying that they want to take FMLA for consecutive weeks, the entire period. They do not have the medical documentation for that. May the agency require them to return to work? Should they require disciplinary action or put the employee on AWOL?
I'm going to do two things. I'm going to toss part of that to Brenda, but I'm going to say what I think, and then you can tell me if I'm dead wrong. I think with regard to the FMLA certification, your absence should be consistent with what you've requested or what your doctor has certified. If there's variance from that, I would think, and this is where I'll ask you, that it would be logical to seek certification for what essentially in some ways is a new request. So that's the part, that's my answer to that part of it. With regard to whether or not there should be discipline, I'm not clear on assuming that everything lines up with regard to those absences. I don't know under what circumstances discipline would be appropriate in that scenario. So, yes.
I would think it would depend on if it was a legitimate request or not. So if they're going by the original medical documentation, I would seek the secondary. So I would go out and get a second opinion, is what I would do in that case. So, but not knowing all the circumstances surrounding it, it's hard to say if I'm on the right track or not.
And another question that just arrived, what if an employee is a veteran who has numerous appointments that require absences? Would this meet the definition of excessive absence if the leave was approved? And may the veteran be disciplined for these absences?
I would say that depends. It sounds like, and again, if factually I'm not accurate, it sounds like what you're talking about are intermittent absences that may happen not so much for consecutive days, weeks, or months, but every so often, or maybe even more than every so often, the person has a medical appointment. So that is not something just off the top of my head that I would jump first to excessive absence. If there's a concern with regard to when appointments are scheduled, or a concern as to whether the appointments are actually happening, I think there are other ways to address it. Excessive absence is generally with regard to consecutive absences over a lengthy period of time. And it's when the employee, essentially, no matter what you say, can't come to work. And that doesn't sound like the situation you just described. All right. So I think we just finished talking excessive absences, and we talked about charges. So let's talk briefly about, once you've noted a problem and you've decided to address it, at the end of the day, if the counseling hasn't worked and you're not on the same page as the employee and you're not having compliance, what can you as a manager or supervisor do? And these are the same disciplinary actions that apply to every form of misconduct. The most lenient and the first step on the progressive action or progressive discipline chart would be a letter of reprimand. And as you see here, stays in your official personnel file for between 1 to 3 years. Sometimes your CBA may call for it to be in for a different length of time. And it can be grieved through your administrative leave, through your administrative grievance process, or through the CBA. It is not appealable to the Merit Systems Protection Board unless it's an element of an individual right of appeal. And it, like any other employment condition or employment action, can be raised as a complaint with the EEOC. If the letter of reprimand hasn't worked, or the misconduct is sufficiently severe that you want to jump right to a suspension, you have your suspensions for 1 to 14 days. Those remain in the OPF forever. They're permanent and they travel with the employee. Also grievable. Not appealable to the board unless through an IRA. And they, like, again, any other action, can be raised with the EEOC. And then for more serious misconduct that's related to leave, you've got suspensions of more than 14 days that are appealable to the board, can be raised with the EEOC. And ultimately, you have a removal. Any and all of these could apply with regard to a violation of leave procedures or policies. And I would say, again, let your decision with regard to what you're choosing be informed by how the person's misconduct, in this case leave-related misconduct, is impacting on your mission, is impacting on the efficiency of your office, is impacting on the environment of your office. All of those are factors that you would need to consider in deciding which disciplinary action to take. Once we've gotten to that point, we've identified a problem and we've counseled and we've determined that the problem is intractable and needs to be dealt with in a more formal way. one thing that comes up frequently, and I think it's always an excellent idea, if you have an employee, and this can happen really at the beginning of the process or at any point, who's having leave-related issues, refer them to EAP. EAP always, I've never, ever, ever made an EAP referral or contacted EAP and not had an absolutely excellent outcome and excellent result. EAP is there to counsel. They're there to help with issues that may be completely not work-related. They'll help with child care. They'll help with elder care. They can counsel with regard to finances, anything that might be impacting an employee's life, and therefore is by definition impacting their work life, is an excellent subject for EAP, and I think it's a great idea to refer your employees. Even at the very beginning where you see a leave issue sort of raising its head, a referral is always a good idea, and there's generally not a downside to it. And that is the end of my slide deck. You see some resources here. I think we've got time for a couple more questions, and I think Brenda had one more item as we wrap up.
Melanie, we have another question with regard to the Cook criteria that you referenced earlier. Several people have asked, what is a general time frame of absence that that criteria may be used?
There's, and I knew that question was coming, there's not actually a specific number or a specific length of time. I generally use, in the several month category, and by several, I would say more than 3 is when you would start thinking about it. And again, this does not include the 12 weeks of FMLA that may have been taken. And so for managers, it sometimes feels like it really, really, really has been forever, but you have to remember that 12 weeks is not something you can count in your total. So I would say, when you're at the end of 2 months, going forward is when you would start looking and certainly start communicating with the employee with regard to the likelihood of their return, because one of the criteria is the medical condition beyond their control. So in order to bring that charge, you have to have some specific knowledge about what's going on with the employee, and you do have to have put them on notice that you're in need of their services with regard to filling the position. So after 2 months is when I would think about giving the Cook notice to the employee. Then going forward, depending on what the response is, you're in a position to decide if that's an appropriate charge.
Another question. Can the speakers give an opinion as to the best practice for a manager who has an employee returning to work after an injury or illness? Can or should the supervisor get a release to full duty?
I'm looking blank, but I'm thinking. I would say it depends. The release to full duty may depend on whether the employee has medical standards or fitness standards in their PD. If there are fitness standards, then certainly you need certification that they can perform the job pursuant to those standards. Depending on the nature of your concern, I would, as a general rule, it's not my practice to ask for release to return to duty. It would depend on why you think you need it, what you think the risk to the risk is with regard to the employee and to the workforce. But as a general rule, if they're coming back to work, you should assume they're cleared by their doctor, unless you have evidence and you need to ask the specific question. But I generally don't ask for releases to return to duty unless there's a specific concern that can be articulated about that particular employee in that particular work environment.
And I guess they want my opinion too. I would say it depends on why you're asking the question. Are you asking the question because you believe that the employee is coming back to duty too soon because they're just one of those people that just have to be at work? If it's that kind of situation, you should probably keep an eye on the individual and make sure they're not doing too much. Offer the flexibilities that are out there in order to help them through this process. They could come back on a more of a part-time basis. They can adjust their schedule. There are a number of things that you could actually do to help that individual until they're fully up to speed and able to perform to the full extent.
And all of that goes back to what we've been talking about. Everything is a conversation. Hi, are you sure you're ready to come back? Okay, well, if you're having trouble, please let me know. If you need an adjustment, if you need leave, if you need something, how can I help you, and let me know what you need, and then you go from there. Managers get into a lot of trouble just making assumptions about what employees can or can't do. And one of the great things about us is we can ask questions and we can get answers, and then you make a decision based on information that you actually have, not just what you're guessing might be the case.
Agree.
Another FMLA question. What happens when an employee has exhausted all of her FMLA but is still having leave issues? Would the agency proceed to a leave restriction or disciplinary action?
I would say that depends on what you mean by leave issues. If you mean they're not coming to work and they're not requesting leave, that's not a leave issue, that's misconduct, and so I would say yes. And from, at least from what's in the question, I don't know what, if anything, that has to do with the FMLA. If they still have a need for leave that is related to the medical condition that precipitated the FMLA, then discipline may or may not be necessary, and you need to talk about whether or not they have sick leave available, whether or not advanced leave is appropriate, whether or not there are other things that can be done. So leave issues is sort of a broad term if it means people just not coming to work and not calling in and following procedures, or if it means they have a need for leave that has extended beyond what's already in place. And that's, again, is a conversation to see what can be done, or it may be a conversation to say we've done all we can, and so we need to think of other options. But I would say it just depends on what leave issues means.
Yes, because you can always provide someone with more leave. If this is a dedicated employee that went out and say they're having just a very bad situation, but eventually they'll be able to come back and perform very well again, you may want to provide them that additional time in order to come up to speed. So, agree. Okay. All right, I guess it's over to me to kind of wrap up our portion. What I wanted to do is just point out to you some of the documents that we have for resources at the very end of your slide deck. One is the Handbook for Leave and Workplace Flexibilities for Childbirth and Adoption and Foster Care. This is something that our staff developed as a result of the President's memorandum from January 15th. It's a 70-page guide that provides examples of different ways that employees can use their leave for childbirth, adoption, and foster care. In fact, it was so successful that the White House and others asked us to do a separate guide on for elder care, and that's the second resource that you'll see there, a handbook on workplace flexibilities for work-life programs. We also developed a online course that's free under hru.gov on the Introduction to Leave, Work-Life, and Workplace Flexibilities that's available to you. The last thing I'd like to mention is to make you aware that we'll be having regulations come out on the disabled veterans leave soon. This was something that was passed from the Wounded Warriors Leave Act of 2015 on November 5th, 2015. We were given 9 months to get out regulations proposed and final on this new category of leave called disabled veterans leave. Provides 104 hours of leave to a veteran who is 30% disabled or more. It only lasts for a 1-year period. It only is provided to anyone who is a new employee after November 5th of this year. Also, we'll be having final regulations come out on religious comp time off. If you're familiar with the religious comp time regulations, they're very, very brief. They don't provide a lot of guidance. So this regulation will provide guidance on how long they have to use the religious comp time. You can ask them for the religious observance that they have. They can, it kind of documents the time that the employee will need to take off for the religious observance and lets them make up the time with respect to when it's convenient for the agency. A lot of this was to prevent abuses that were out there where people were just accumulating large amounts of religious comp time and just taking off. So they should be out, I would say, probably in September. Disabled veterans leave will be out by August 6th because it's mandated by law that we have regulations out by August 6th. And that's all I have. Over to you, Cynthia.
Thank you so much, Brenda and Melanie. On behalf of Partnership and Labor Relations, we appreciate your sharing your expertise during today's roundtable on understanding leave options in the federal workplace and misconduct implications. Your presentation has provided an outstanding and in-depth overview of the federal leave system and how to address conduct issues that may arise related to time and attendance and leave abuse. I thank as well OPM's communication staff for your webcast of the roundtable, and thanks to my colleagues in Partnership and Labor Relations for your work on this dynamic roundtable. And thank you for participating today. We look forward to having you at the next Employee and Labor Relations Roundtable. Finally, please remember that shortly you will receive an email with a hyperlink to an online evaluation form courtesy of SurveyMonkey.com. Your feedback helps us to plan future roundtables, and we appreciate your taking the time to complete this survey. Have a great afternoon.